Welcome to Section 2B, Supervision of Associated Persons. Remember, Critical Function 2 will be a total of 49 questions on your exam. Let's get started. FINRA Rule 5270 has to do with front-running of what's called a block transaction. So you will want to know the definition within this rule, FINRA Rule 5270, of what is a block transaction. A block transaction is a transaction in equity securities of 10,000 shares or more. So that is within this rule the definition of a block transaction. Now, within the rule, it reminds you, do not, as a broker-dealer, trade ahead of a block transaction. So by giving you this definition, you know what a block transaction is, but of course, the rule also says it is possible that a transaction of fewer than 10,000 shares could be also considered a block transaction. Isn't that always how they write the rules? So focus on the 10,000 or more as being most generally the definition of a block transaction, although in certain contexts, less than that could also be. So this idea that the member firm or person associated with the member shall not cause to be executed in order to buy or sell a security or a related financial instrument when such member or associated person has material, non-public market information concerning an imminent block transaction in that security, a related financial instrument, or a security underlying the related financial instrument prior to the time the information concerning the block transaction has been made publicly available. So if the firm knows about an imminent block transaction but it hasn't been executed yet, the firm cannot trade ahead of this non-public block transaction. No front running, which really is a rule you probably have heard in the past. The rule applies to orders caused to be executed for any account in which such member or person associated with the member has an interest, any account with respect to which such member or person associated with the member exercises investment discretion, or for accounts of customers or accounts of affiliates. So if you, let's say you're a registered rep, you know about this not publicly made known imminent block transaction, you can't make discretionary trades for your customer's account. No proprietary trading for the firm until the details of the block transaction are made public. Within this rule, it reminds you that it would be a violation to execute a transaction based upon knowledge of even less than all of the terms of the imminent block transaction, so long as you're sure that it's going to occur. So if you know a little bit about the imminent block transaction, but not everything about the block transaction, you, the broker-dealer, should not engage in front-running of that transaction. When can you trade in that security? When the information regarding the block transaction has been made public. So when is it made public? When it is disseminated via a last sale reporting system or high-speed communication line of one of those systems, an alternative trading system, or a third-party news wire service. The requirement that the information concerning a block transaction be made publicly available will not be satisfied until the entire block transaction has been completed and publicly reported. Then you can make recommendations to buy and sell based in that security because it's no longer private or inside information anymore. So block transactions, 10,000 or more shares generally is the rule. Now, Rule 5270 does not prohibit certain transactions that you can prove are unrelated to the material non-public information that you have. These types of allowable transactions include transactions where the member has information barriers established to prevent internal disclosure of such information, Transactions in the same security related to a prior customer order in that security. Transactions to correct bona fide errors, and transactions to offset odd lot orders. So if your client placed a trade to buy the same security in which you later learn of an imminent block transaction, you can still process that customer's trade. You didn't make a recommendation. The order has nothing to do with the information that you have. You didn't discretionarily choose that for your client. It also reminds you within Rule 5270 that we define block, 10,000 shares or more, that transactions ahead of other orders are also prohibited as well. So this idea that the broker-dealer should not trade ahead of customer limit orders is not necessarily a violation of Rule 5270, it's violations of other FINRA rules. So no misusing information about your customer orders for the benefit of the firm. Of course not. No front running, ever. It's not allowed. Broker-dealers are not allowed to engage in front running. The Securities Exchange Act of 1934 has a rule, it's 10b-5, employment of manipulative and deceptive devices. Don't those just sound bad? Don't do them. So there's a lot of rules that are referenced on the content outline that are basically common sense. You won't be asked what's 10b-5 ever. I've told you that many times. But this idea that it is unlawful for any person, directly or indirectly, by the use of any means or instrumentality of interstate commerce or of the mails, or of any facility of any national securities exchange. These are all prohibited. They're manipulative and deceptive devices. So do not employ any device, scheme, or artifice to defraud. Do not make any untrue statement of a material fact. Do not omit to state material facts necessary in order to make the statements made in light of the circumstances under which they were made not misleading. Do not engage in any act, practice, or course of business which operates or would operate as a fraud or deceit upon any person in connection with the purchase or sale of any security. No manipulative or deceptive practices. No, of course not. Within the same rule, there is a definition of what is considered to be trading on the basis of material, non-public information. So you know you should never do that, and we'll talk about it under lots of different rules. So within the term manipulative and deceptive device, within Rule 10b-5, this is actually -1 of that rule, the Act prohibits trading on the basis of material non-public information. It is considered a breach of a duty of trust or confidence that is owed directly, indirectly, or derivatively to the issuer of that security or the shareholders of that issuer or to any other person who is the source of the material non-public information. So to trade based on inside information is a manipulative and deceptive device. A purchase or sale is considered to be made on the basis of inside material non-public information if the person making the purchase or sale was aware of the material non-public information when the person made the purchase or sale. Seems logical. So if I make a trade for a customer on a Monday and find out information that's inside on a Friday, the trade on the Monday is not on the basis of material non-public information. So what is allowed, what will be considered not to be a violation, not on the basis of? If the person making the purchase or sale can demonstrate that before becoming aware of the information, the person had entered into a binding contract to purchase or sell the security, like I just showed you, instructed another person to purchase or sell the security, or adopted a written plan for trading securities. It will also be allowable, not considered trading on the basis of inside information, if the person making the purchase or sale can demonstrate that the contract, instruction, or plan specified the amount of securities to be purchased or sold and the price at which and the date on which the securities were to be purchased or sold, included a written formula or algorithm or computer program for determining the amount of securities to be purchased or sold, and the price at which and the date on which the securities were to be purchased or sold, or did not permit the person to exercise any subsequent influence over how, when, or whether to effect purchases or sales. So if you did that transaction on a Monday, found out inside information on the Friday, no more trading in that specific security until the information is no longer inside, until it has been made public. A person other than a natural person can demonstrate that a purchase or sale is not on the basis of material, non-public information if that person can demonstrate that the individual making the investment decision on behalf of the person to purchase or sell the security was not aware of the information, and the person had implemented reasonable policies and procedures, taking into consideration the nature of the person's business, to ensure that individuals making investment decisions would not violate the laws prohibiting trading on the basis of material, non-public information. So there's this idea that all broker-dealers should have they call it sometimes a China wall or a Chinese wall between inside information and the proprietary trading desk. So if the other than a natural person, so that's a firm, can prove that the person making the trade didn't know this inside information, well then it's perfectly fine. It will not be trading on the basis of inside information. SEC Rule 10b-5-2 reminds us that these rules as far as duties of trust or confidence in misappropriation insider trading cases, the scope of the rule. This section shall apply to any violation of Section 10b of the Act and Rule 10b-5 that is based on the purchase or sale of securities on the basis of or the communication of material non-public information misappropriated in breach of a duty of trust or confidence. So sometimes people tell you things and they expect you to not share them and they expect you to not trade based upon them. So it goes on to define, when do you have, as a registered rep, as an associated person, a duty of trust or confidence? Whenever a person agrees to maintain information in confidence, you can't trade based on that. You can't recommend those securities to buy or sell to your customers. Whenever the person communicating the material non-public information and the person to whom it is communicated have a history, pattern, or practice of sharing confidences, such that the recipient of the information knows or reasonably should know that the person communicating the material non-public information expects the recipient will maintain its confidentiality. Or, whenever a person receives or obtains material non-public information from his or her spouse, parent, child, or sibling. So your daughter is the CFO for a publicly traded company and she calls to tell you she's going to have to restate last quarter's earnings. And you want to trade, you can't trade based on this. She told you it's a duty, it's a confidence, it's not been made public yet. Of course you can't trade based upon that. Section 15C1, the use of manipulative or deceptive devices. Once again, bad. So we see these terms more than once. It goes to further define to whom do these rules apply. So broker-dealers, including municipal securities dealers and government securities brokers and government securities dealers, shall not make use of the mails or any means or instrumentality of interstate commerce to effect a transaction in or induce or attempt to induce a purchase or sale of any security otherwise than on a national securities exchange of which it is a member, by means of any manipulative, deceptive, or other fraudulent device or contrivance. So no scheming, no use of the mails to scheme. So this applies, like I said, to broker-dealers, municipal securities dealers, government securities brokers, and dealers. It goes on to remind us, the broker-dealers, municipal securities dealers, government securities brokers and dealers shall not make use of the mails or any means or instrumentality of interstate commerce to effect a transaction in or induce or attempt to induce the purchase or sale of any securities otherwise than on a national exchange of which it is a member, in connection with which such broker or dealer engages in fraudulent, deceptive, or manipulative acts or practices, or makes any fictitious quotation. So really the only part of that that's new is no fictitious quotations. Seems like a reasonable rule to me. Broker-dealers shall not make use of the mails or any means or instrumentality of interstate commerce to effect a transaction in or induce or attempt to induce the purchase or sale of any security in violation of rules and regulations of the SEC. The SEC has the authority to make rules and regulations as necessary to safeguard the public for the protection of investors. So the SEC has the authority to make rules, to set safeguards. Broker-dealers are subject to financial responsibility rules, rules related to the custody and use of customer securities, and the carrying and use of customers' deposits and credit balances. So net capital requirements, for example. So it's basically within this section that the SEC is given the authority to make the rules that relate to how much net capital the firm can have on hand, how much debt they can take on versus their net capital. So we'll learn all of that in a subsequent section. Under this section, the SEC is also given the authority to make rules as necessary to protect the public, to protect investors, so that we have fair and orderly markets, to remove impediments, to perfect the mechanism of the national market system. It is possible that the Commission can bar a broker-dealer from acting as a dealer in a security, from acting as a broker in a security, if they have violated federal securities laws. The SEC also has the authority to prescribe rules as necessary to protect the public, to protect investors, to perfect and remove impediments to this national market system so that there is prompt and accurate clearance and settlement of securities transactions with respect to the time and method of and the form and format of documents used in connection with making settlement of and payments for transactions in securities, making transfers and deliveries of securities and closing accounts. So this gives the SEC authority to make those rules, which we'll learn later if we need to learn them for this test. Some tests will care about those transfer rules and some don't. Under this section, in connection with any bid for or purchase of a government security related to an offering of government securities by or on behalf of an issuer, no government securities broker, government securities dealer, or bidder for or purchaser of securities in such offering shall knowingly or willfully make any false or misleading written statement or omit any fact necessary to make any written statement not misleading. So all within the guise of manipulative and deceptive device. So whether or not it's in government securities, it's in interstate commerce, it is a municipal securities dealer. Do not engage in fraudulent or deceptive devices. Do not omit material facts. Do not make untrue statements. Under Section 15C1 of the Securities Exchange Act of 1934, there is a prohibition of referral fees. No broker-dealer or person associated with a broker-dealer may solicit or accept, directly or indirectly, payment for assisting an attorney in obtaining the representation of any person in any private action arising under this title or under the Securities Act of 1933. So lawyers cannot pay broker-dealers or associated persons for referrals anytime there is a lawsuit related to either the Securities Exchange Act of 1934 or the Securities Act of 1933. Prohibition on referral fees. Under Rule 15C 1-1, we learn what it means, the definition of the completion of the transaction. The completion of the transaction. In the case of a customer who buys a security through or from a broker-dealer, including municipal securities dealers, the completion of the transaction is the time when such customer pays the broker-dealer. Or if payment is affected by a bookkeeping entry, it's the time when such bookkeeping entry is made by the broker-dealer. So when the customer purchases a security at completion of the transaction is when they pay for it. So they could place the trade and pay for it 3 days later, or really up to 5 days later. So when they're purchasing, it's when they pay for it, which makes sense. In the case of a customer who purchases a security through or from a broker-dealer and who makes payment prior to the time when payment is requested, the time when the broker-dealer delivers the security to or into the account of a customer is considered the completion of the transaction. So if they pay before they have to pay, then at the completion of the transaction is when the broker-dealer delivers the security to or into the account of the customer. If the customer is selling a security through a broker-dealer, if the security is not in the custody of the broker-dealer, completion of the transaction is the time when the security is delivered to the broker-dealer. If the security is in the custody of the broker-dealer, then at completion of the transaction is the time when the broker-dealer or municipal securities dealer transfers the security from the account of the customer. The completion of the transaction in the case of a customer who sells a security through a broker-dealer, when the customer delivers the security to the broker-dealer prior to when delivery is due, then the completion of the transaction is when the broker-dealer makes payment into the account of such customer. SEC Rule 15C 1-2 is fraud and misrepresentation. Again, another one. So the term manipulative, deceptive, or other fraudulent device or contrivance is defined to include any act, practice, or course of business which operates or would operate as a fraud or deceit upon any person. So I expect you'll see lots of questions about should you do these things. They'll give you examples. Don't. It is defined to include, so manipulative, deceptive, and other fraudulent device is defined to include any untrue statement of a material fact, any omission to state a material fact. So they love this idea, do you have to state all facts? No, you have to state all material facts. You cannot make an omission of a material fact. You cannot make an untrue statement. So it comes up many times. They also like, under 15C 1-3, there are certain misrepresentations that broker-dealers and municipal securities dealers should not make in regards to their registration. It would be considered a manipulative, deceptive, or other fraudulent device or contrivance to include any representation by a broker-dealer or municipal securities dealer that the registration of such broker-dealer or municipal securities dealer, since it has not been denied or revoked by the Commission, indicates in any way that the Commission has passed upon or approved the financial standing, business, or conduct of such registered broker, dealer, or municipal securities dealer, or passed upon the merits of any security or any transaction. So the SEC never approves any broker-dealer, never passes upon their business strategy, their financial health, never approves anyone. You can say the broker-dealer is registered with the SEC, if in fact true. You can say that the security is registered, if in fact true, but you can never say because it's registered, it's approved. The merits have never been passed upon. That would open up the SEC for legal liability, which of course they do not want. The Investment Company Act of 1940 has what's called Section 37. And Section 37 is all about reminding us that whoever steals, unlawfully abstracts, unlawfully and willingly converts to his own use or to the use of another, or embezzles any of the monies, funds, securities, credit, property, or assets of any registered investment company shall be deemed to be guilty of a crime, and upon conviction shall be subject to the penalties provided by law. Do not steal or embezzle from an investment company. So have your moral compass on high when you're taking your test. That should really help. Section 24B of the Investment Company Act of 1940 requires the filing of 3 copies of an advertisement or pamphlet that is going to be used in connection with a public offering of investment company securities. So the way that this rule works is that all investment companies, whether or not they're a registered open-end company, a registered unit investment trust, or a registered face amount certificate company, are required to file 3 copies of the full advertisement of the pamphlet with the SEC within 10 days of first use. So a lot of times we talk about FINRA rules as it relates to sales and advertising material. This is a rule that says the sales and advertising material is filed with the SEC. How many copies? When there's an open-end mutual fund IPO, which is an ongoing IPO, right? How many copies are filed with the SEC? 3. I would definitely know that. It is true, however, a little bit later on in the Investment Company Act of 1940 that the advertisement, pamphlet, circular, form letter, or any other sales literature that is addressed to or intended for distribution to prospective investors is deemed to be filed with the SEC if it is filed with a National Securities Association that's registered with the SEC. So that's what FINRA is. A lot of times we call FINRA an SRO, a self-regulatory organization, which is what they are. They're actually also a national registered securities association. It's the only one we have here in the US. So how many copies? 3. When? Within 10 days after first use. So it doesn't have to be used or doesn't have to be filed prior to, within 10 days of first use. FINRA Rule 2060. Use of information obtained in a fiduciary capacity. Somewhat familiar idea. Should you use information that you've obtained in a fiduciary capacity? Nah, not today. A member firm who, in the capacity of paying agent, transfer agent, trustee, or in any other similar capacity, that has received information as to the ownership of securities shall under no circumstances make use of such information for the purpose of soliciting purchases, sales, or exchanges, except at the request of and on behalf of the issuer of the securities. So when you're the transfer agent, when you're the trustee, you're the paying agent, you have information that really is only for you to know. It's not public information. You cannot trade based upon it. FINRA Rule 2330 has to do with the member's responsibility regarding deferred variable annuities. Deferred variable annuities. I would expect a handful of questions will come in this area.